Good morning, fellow panelists and the eminent audience. I must confess at the very beginning that I'm not a lawyer in this sea of lawyers, so pardon my ignorance of law. But I do implementation of law and regulations on a day-to-day basis, so maybe I'll speak from that perspective. The topic is on digitization and balancing that with the right to privacy. So I would just like to flag where we are on digitization in India. The process over the past 10 to 15 years has been going on, but I think in 2015, the Digital India was launched with the objective of ensuring that digitization, not only within the government, but outside the government increases. And I think the last 3 years during COVID-19 have only highlighted how technology can improve governance, can improve and increase public service delivery, can help in transparency, and also help in building citizens' trust. And I'm sure a lot of you would have seen the CoWIN app that got developed. Because of this focus on digitization over the past many years, especially since 2015, there's been a lot of pioneering work done in India, and I think the path that India has followed has been slightly different, at least from the two groups that are being compared to the US and Europe. We've used the architecture of digital public infrastructure and combining that with private-led market innovation. And I think that's the way we have digitized, and I can just mention some of these digital public infrastructure that have been built. Aadhaar is prominently one of the DPIs, and which is the foundational DPI, if I can put it that way. And apart from that, we have a host of others, including the UPI, the Unified Payments Interface, where you do more than 30 billion transactions every month. Aadhaar itself, we've really had near universal identity across the country to all residents, with 1.35 billion having the Aadhaar identity. Apart from that, e-commerce, where we have the government e-marketplace, where nearly $14 billion of trade and merchandise is traded for the government procurement, and the ONDC, the Open Network for Digital Commerce, is under implementation. I mentioned about CoWIN, which has done about 2.2 billion vaccinations, and it could be tracked so easily, and we could do it within a period of 1 year, ramping up from maybe 100 million vaccinations to more than a billion or 1.2 billion within 12 months. So I think a lot of this is based on the approach that we have followed in the DPI, and which is open source, open architecture, and open networks. The focus being scalability, affordability, and interoperability, and which is key to the basis of digitization that we are following, and that has also led to the growth of this. And this has also led to one other advantage, that we have perhaps one of the lowest cost in any of these sectors that you look at. I'll just look at telecom, where the cost of data per gigabyte is one of the lowest in India. And that's why we are one of the highest users of data as a country, despite the socioeconomic status being, in terms of per capita incomes, much lower than many countries across the world. We have 1.17 billion people who have phones, around 800 million have smartphones. Digital payments, similarly, 40% of the global digital payments happen in India, albeit of lower transaction value, but the volumes are really great. And that, because of this low cost, I think that focus on ensuring inclusion is there. BharatNet program to ensure that telecom connectivity is there, even in each of the 650,000 villages that we have. The digitization helped us to open 450 million bank accounts within a period of 5 to 6 years, that we have now reached an 80% penetration of banking of people in the country with more than 1.4 billion bank accounts. And all this has led to the JAM Trinity, which is the Jan Dhan Aadhaar Mobile, Aadhaar being the identity foundation, mobile having 1.35 billion Aadhaars, 1.17 billion phones, and 1.4 billion bank accounts, which has led to the direct benefit transfers, which during the COVID time also was extremely useful in transferring benefits. In fact, if we look at in the past 7 to 8 years, around $300 billion of benefits have been transmitted from the government, state governments, central governments to people because of the ability to reach a person at the last mile through depositing in the bank, and the person can withdraw withdraw money from the bank account without visiting a brick and mortar branch because of the Aadhaar-enabled payment systems by which a card reader becomes the basis for which you can operate your banking account through the more than 500,000 citizen service centers, etc. So why I wanted to place this is that the level of digitization is much, much greater than what is normally known. And though as of now, around 8.5% of the economy is what is considered as the digital economy. But you must remember that what is called as a digitally dependent economy is nearly 22% of the GDP. So it's nearly 1/4 already. And the growth of the digital economy, if you just look at the 5-year period, 2014 to 19, for which the data is clearly available, was 2.4 times faster than the other parts of the economy. And even now we have more than 62 million workers dependent on the digital economy. And I think going forward, the rate of pace of change is so much faster that the goal of having a 1 trillion digital economy by 2025 is something I think that would be very easily to be achieved. And the focus in all this is inclusivity, as I mentioned. In fact, we are having this Bhashani program where each of the 4 different languages you can interpret and access the internet through that. And if we look at the internet subscriptions, they increased by more than 200% in the 5-year period from 2015 to 2021. So going forward, I think its digitization is there and it's going to only increase. And I think the topic today on balancing digitization and right to privacy, I think is very appropriate. I would just like to talk of the 2 judgments in 2017 and 2018 of the Supreme Court, normally referred to as the Puttaswamy judgments, one looking at right to privacy, another looking at the Aadhaar Act itself. And I think they looked at it in a very holistic manner. I'm sure my friend lawyers would be much better able to explain that. But I do want to mention that the right to privacy was upheld as to be a part of the right to life and personal liberty under Article 21 of the Constitution, and it was constituted as an integral part of human dignity. The 2018 judgment also looked at it and also held that integral to Article 21, integral to the right to life and personal liberty is also the right to food, shelter, and employment, the right to better living standards, which is also an integral part of human dignity. And I think that's the balance that these judgments have led us to look at. And it's very important that right to liberty, right to dignity, right to privacy, and the right to better living standards all go together. And we need to maintain that balance. And I think that's the balance that all of us are trying to do and ensure that we do it so that the welfare benefits to the most unprivileged and the marginalized sections of the society, they are not bereft of these benefits. Obviously, the tests of proportionality are there. To lawyers, I don't need to talk about that, but I think that's where the balancing is also required apart from looking at other balancing. I'm conscious of the time that the moderator had mentioned. So I'll just briefly mention on how we try to maintain that balance in Aadhaar. We have privacy by design, by the fact that we are purpose agnostic. We have 1.35 billion people who have the demographic details and the biometric. We ensure that we have minimal data. We don't have any tracking information, whether it's religion, ethnicity, income, caste. We have minimal data, and we are purpose agnostic. And something we follow privacy by policy is in terms of there's obfuscation by choice. If a resident wants to have a virtual ID, they can do that. Primacy of consent is something that is integral to how whenever Aadhaar is used for any purpose, which helps that person to be able to get the benefit of any benefit, subsidy, or service. Associated very often with privacy is also cybersecurity, because that's that's a different domain, but that can impinge on privacy. And I think that's also something by design we have. We follow encryption of data, we follow sharded databases, network segmentation. I can go to a host of kind of terms, but the fact remains that we only allow trusted partners to access, whom we do a regular audit of what is the kind of data, whether there's been any data, multiple firewalls and monitoring of all this activity. So I think coming back to where I started on the digital public infrastructure, which forms the basis of digitization of the various activities that we are doing. And it is helping us to deliver to the society services, including to marginalized communities, and while keeping privacy safeguards as a part of the technological design. And I would just mention three things that we maintain. One is that citizens should have the access to use that data for their own benefit, and that's why we have the right that even the Aadhaar data can be used by anyone for their own access, for their own benefit, and that's why you would see everywhere people use that as the default ID card. The rules of access are clear and allow for sharing of consent while respecting privacy. That's built into the Act itself. And thirdly, the system must be digital, otherwise with data protection principles built in. And I think with a combination of this, we've been able to ensure that the DPI ecosystem, the digital public ecosystem, provides the pathway to democratize data with people having control over their own data under the broad framework of the data empowerment and protection architecture. So with this, I'll end, and thank you. Thank you for inviting me. It's a pleasure to be out here. Thank you.
Welcome, ladies and gentlemen, and distinguished guests. This is a very interesting topic, very international, as would befit the ABA international section. We are trying to cover here the balance of digitization and the right of privacy between three jurisdictions primarily, the US, Europe, and India. As we know, the US is the home of the big data giants such as Meta, Amazon, Facebook, as well as Google. And that creates a very strong stakeholder consensus there to have a lot of digitization, a lot of private digitization. At the same time, the US has very strong human rights record and a very robust approach to individual rights. The European Union, as we know, has been the pioneer through the GDPR, through growing the strongest, perhaps, culture of privacy that is known globally. Right? They have always had a very strong offline culture of privacy, which is not there in many societies. And then you have India, which is remains a developing economy, remains a home perhaps to the largest population in the world, going by certain numbers which were put out last month, and therefore a huge amount of personal data. At the same time, we need digitization, but as Dr. Garg pointed out, the Puttaswamy judgment of the Supreme Court has made clear that privacy is a fundamental human right. So that is the background to the session. If I could start perhaps with Sahana. So Sahana, if you could tell me a little bit now, the Honorable Minister pointed out that the Digital Privacy Bill is now cleared the Standing Committee and will probably be introduced in the second half of the monsoon session, or indeed the budget session. So do you feel that the bill lacks the relevant amount of teeth that you would have liked to see? to ensure privacy as a human right? Or do you think it's a good balance between digitization and privacy?
Thanks, Avimukt, for that question, and thank you to ABA for having this conference and to inviting us to this session. Like Avimukt said, it's a very important issue and the right time to be having these discussions. I think the bill in its current form, to me, has been a very interesting evolution of the privacy dialogue in India. The privacy dialogue in substance started really around 2016-17, as we saw the Puttaswamy judgments coming in, as we saw the formulation of the expert committee under Justice Shri Krishna. There has been a huge amount of consultation, a massive amount of engagement, and as a policy professional, to me, this has been one of those landmark legislations that has seen this quantum and this intensity of engagement, which is absolutely great. And we've seen the bill in itself go through many iterations, right? There was recommendations from the expert committee. There was the draft of the government, which was finally taken to Parliament. There was a report of the Joint Parliamentary Committee. Each one had a slightly separate focus. Each one had a slightly, different point of view from which it was coming. And I think the manner in which the DPDP bill has now been formulated perhaps represents the best attempt at balancing the kinds of rights that have now been read into the fundamental right, the right to privacy, and the kind of innovation and support to the digital sector that we see as an objective for the government. India has very clear aspirations for becoming, one of the strongest digital economy. Dr. Garg has already told us about the massive amount of, transactions that are happening to build the digital economy. And I think the DPDP bill is an attempt at striking that balance. That said, it is also, unfortunately, I feel like I'm not going to be able to answer your question completely because there isn't very much substance to the bill that we can discuss and that we can evaluate and determine what the impact ultimately will be. Whether it is on your and my right to privacy or whether it is the ability for a tech-intensive sector or a tech-intensive entity to undertake business here in India. And again, that might be the only approach that works, to have a principle-based approach which is dynamic, which will then stand the test of tech innovation, allow innovation to take place at a certain time, but have certain principles that, that sort of innovation will always adhere to, keeping in mind the right to privacy. So perhaps in that context, a principle-based legislation is the only answer, is the only solution, with having a lot of substance set out in subordinate legislation. I think if there are, a couple of things that are followed through as we're thinking about subordinate legislation, if there are checks and balances, if there is appropriate amount of consultation as we're developing the substance of this bill through the subordinate legislation, perhaps it'll be the different stakeholders who are able to strike that balance, make sure that, whatever the subordinate legislation ultimately looks like, speaks to that balance of protecting the right to privacy, but still encouraging innovation, might be the way forward. Now, all of that said, as all of us, I think, on this panel who have been following the evolution of the privacy law in India, I'm very keen to see it come into passage. I'm very keen to see it to come into act. I think this is a start of a whole separate journey. And I think there is scope for improvement under the bill. I think some of the broad exemptions given to the government are fairly quite concerning. And it'll be interesting to see how that is balanced against the right to privacy. But despite all of this, I think it's time that we have a data protection bill in India.
Thanks, Hannah. In fact, that's a very interesting point you mentioned, the principles of subordinated legislation. This is a very strong policy push over the last decade where legislation is high level by Parliament and then it is left to the government to add more color to that legislation. We do have a master of subordinate legislation, which is the Reserve Bank of India, right? So they've been at it for decades, and in the vacuum created of the lack of a data protection law, they have filled that vacuum to a great space in payments, in fintech, across the board. And it may be strange for a lot of international lawyers because you don't typically see the Bank of England or the Federal Reserve Bank being a data protection authority. But de facto, we do have that in India, in the RBI and its data localization and data protection laws. So Garima, running the legal function in MobiKwik, which is a financial services company, what has been your experience of RBI as a de facto data protection authority in India?
Thanks, Avimukt, and thanks, ABA, for having us here and discussing this extremely important and pertinent topic. I totally endorse, what Avimukt just said. I've been in the space for, I think, a little over a decade, and I have been privileged to actually, seen a lot of changes in the regulatory landscape and some very prominent watershed moments, wherein I can very safely say that RBI in some sense is following the gold standards, it is following the global standards, even before this bill will become into an act. Three very prominent developments which have happened in the last, I would say, 5, 6 years. 2018, when RBI had, come up with a diktat that all payment service providers will store the data localized in India, and we have to give them annual undertakings as to we are complying with this particular regulation. Now, the basic intent, I would say, was increase in visibility, increase in control of data, and that was the intent of RBI. This particular diktat was, of course, the onus of compliance was on the PSOs, but the applicability was on everyone who was connected with the PSO. For instance, I have a tool, I do data analytics for a regulated entity. I have to make sure that my data, that data of that regulated entity is localized, is stored within India. It was very clear. And if that doesn't happen, the penalty will be on that particular regulated entity. So the onus of compliance was there, but the expectation of compliance was even with a non-regulated entity. So that, I think that was one very momentous occasion, and at that time I was associated with the fintech, which had been acquired by a bank. And I remember 6 months, it was a labor-intensive and a capital-intensive activity wherein we were supposed to get all the data from servers located abroad to India, And I mean, of course, a lot of entities have also been penalized with that, on that perspective for not following this particular diktat. I think if I move a little further, more than a couple of years back, we have something like a tokenization. RBI again came up with this mandate that, for instance, you go to in layman terms, you go to a food, I'm a customer of a food delivery app. I go to that app, I punch in my card details, I do a save card. Before 2022 October, that card details could be stored by any entity which was a PCI DSS compliant entity. It can be a payment issuer, it can be a card network, it can be any payment service provider, a TSP. The only, I would say, applicability was that you have to be a PCI DSS compliant entity. Your data will be stored in an encrypted manner. RBI said nothing doing. I cannot manage, so much exposure to customer card data. The outcome was that RBI came up with this mandate that only 2 entities will be allowed to store card data. First of all, the card data has to be converted into a token, which will be a unique token. So when you go to a food delivery app now, you're actually giving them consent to store card data in a form of a token. It is not really your card data. Of course, there are some exceptions regarding transaction tracking and all, but you're actually giving them consent for a token and not for your card data. Post-October, the whole card data by all fintechs, by all payment service providers who are not issuers and card networks were supposed to be purged. This was, again, I would say, a massive activity. I saw it happening in front of my own eyes. Our tech teams, our product teams, trying to figure out how to tokenize the data, how to gather consent of millions of customers we had on our platform. The third, I think, and the most recent one is the digital lending guidelines. The digital lending framework in India we have a lender. We have an app who's facilitating that lending, helping in underwriting, helping in sourcing of customer, and helping in collection of that debt, collection of the loan, repayment of the loan. Of course, there's a lot of to and fro of data. I think there RBI has gone one step ahead and said that the customer will actually have a right to revoke the consent for the data as well, which is stored. At any point of time, the customer can ask the particular LSP or a loan service app to delete the data also. The consent framework has to be really clear. The customer has to know for which purpose the consent has to be given. As a result of which, most of the LSPs who were working in a particular model, they had to actually ensure that the customer journey is such that the consent, the explicit consent is captured, it is time-stamped, and it is auditable. And of course, the fourth thing is that, the revocation right was given to the customer at any point of time. So I think the whole digital landscape with these three developments, I would say, has kind of changed. If I compare it with the current bill, of course, as Sahana mentioned, the granular details are missing just for some reason. Data localization, there is a mention that there will be some whitelisting which will happen. But I think RBI managed to do that way before in 2018. So, my parting remarks on this whole thing is that, I would like to quote what the Deputy Governor said very recently on one of the occasions, that, the innovation has to be encouraged. Second, the innovation should be assimilated in the financial system in a very non-disruptive way. And third, the course of digitization should at every step ensure customer protection. So with more and more adoption of digital payments in the landscape of India, where even subprime customers, even a roadside vendor is ready to adopt digital payments, is ready to put that QR code on his shop. I think we have to be extremely, we have to ensure that customer protection has to be at the paramount of any innovation. That has to be a P0, and customer protection comes with data privacy, how we store the data of the customer, how is it cascaded, and it has to be within the guardrails of the regulator of the act. Thank you.
Thank you, Garima. Dr. Garg mentioned privacy by design. Now, that brings us to Nikhil, and not that he's private by design, but he has spent a lot of time working with US clients on privacy issues where they mesh their privacy policies with Indian policies. As I mentioned, the US is a bit unique in that it has a very strong culture of privacy, very strong culture of privacy as a human right, and indeed a strong culture of human rights itself. And at the same time, it is the home to some of the biggest technology and big data companies that are there. And on top of that, they also have a federal system of government where each state, for instance, most notoriously California, can keep coming up with new laws for privacy. So So what has been your experience like? Is it very sectoral there, or is it something where they can finally come up with one law which fits all?
Yeah, so couple of things. One is I don't totally agree that the US has got a great record in human rights, right? If you just look at their, general policy on healthcare, education, even for that matter, some aspects of free speech itself, it doesn't have that much of a great record when it comes to human rights. And it's more of a libertarian state rather than a liberal state in many senses, right? So, and my comments here are largely from the perspective of an alien perspective, because I, spend a lot of time in the US, I work with a lot of US clients. So the US, the right to privacy, like you mentioned, that's been recognized, but it's a very different right when it comes to, rest of the world, right? If you compare Europe or if you compare India for that matter. For instance, average citizen in US do not have any problem in completely wiring up their smart home and giving data to companies without even looking at terms and conditions. They won't even consent to that data sharing. They have absolutely no problem in doing that. But if you just walk up to their home and try to take a selfie in front of their house, they have a problem and they could even call a cop on you, right? So it's very different. The concept of privacy in different, at least in different states also, it's very different, right? The second aspect to think about US is, look, US, there's been some movement on the Capitol Hill to try and come up with a law, because this approach that US has taken, which is very similar to the approach that we have had so far, which is a sectoral approach to privacy, works very well in certain sectors. For instance, the HIPAA, it works brilliantly, right? I don't know if you've seen this famous video of, this interview of, Dr. Fauci going to take a, shot, a COVID shot, and the reporter who's sitting next to him asks this particular male nurse as to, which are the other celebrities that you've actually given the prick to, and he refused to answer because HIPAA works brilliantly in the US. For instance, the Graeme-Leach Act, which talks about financial security privacy, works brilliantly in the US. But when it comes to consumer tech, the US privacy law is completely divided. They don't have a proper law. It's largely the approaches from CCPA, the Californian Act, and a few other states also have this act, which has actually created an issue because they're finding it difficult to come up with a standard that will apply to data collections and practices, right? I mean, just imagine all states in India have a privacy law its own. How difficult will it be? What standards will the company follow? It's a mess, if you just ask me. But unfortunately, the Capitol Hill, the situation in US, as you know, it's a bipartisan politics in US. The Democrats and the Republicans are unable to meet eye to eye when it comes to the concept of privacy. Because, for a simple example, you have the right to bodily privacy. That starts with the right of a woman over her body. The Republicans have a completely different stand. The Democrats have a completely different stand, right? But they're all very united in the sense that they all want to regulate the big tech. They want to regulate the big tech, and they want to regulate some aspect of informational privacy, but they are at completely opposite ends of the spectrum when it comes to how to go about that regulation. And that's a situation that US has landed itself. And then it has an FTC, which is a very powerful regulator, right, which looks into aspects relating to consumer privacy. And as you know, the famous regulator, Sarina Khan, so she's been leading the effort in terms of regulation, but there is only so much capacity that FTC as an organization to have to focus just on aspects relating to privacy. So unless there is a strong law that comes out, like, we have done, right, India has done. And I think what we have done in India is that we have actually not gone the US way. We've probably been, the situation in India was very similar to what it was in the US. We have sort of taken some principles which are from GDPR. We have taken a very business-friendly approach, which is very different from GDPR, and come up with a law which sort of balances some of these aspects, keeping in mind the digital public infrastructure, like the Open Network for Digital Commerce or the UPI that's been implemented by the government, and sort of trying to create a model of law which will work for the Indian realities. And we should all keep in mind the fact that, look, we've got a large number of population to lift out of poverty, and from poverty to middle class to even opulence, we have that duty to do that, and the government and the regulators in this country have the duty to do that. So in that sense, the law that we have come out with is something which balances the commercial interests rather than on the human rights or the individual human rights, which is actually the sad part of it, but I'll let others comment on it.
No, thanks for that, Nikhil. In fact, it's quite interesting that the US had a very strong championing of digital companies till TikTok came along, right? So we saw in 2020, suddenly there was a concern amongst lawmakers regarding teenagers' right to privacy over TikTok, and the then president tried to ban TikTok for that reason. So there is always an element of data sovereignty amongst policymakers, be it in India, in Europe, or in the US, when they formulate data privacy laws. And we see that theme run across jurisdictions. So Vasudha, coming to the most interesting jurisdiction of them all, which is the European Union, as I mentioned earlier, they do have a very strong privacy culture. And Nikhil mentioned this also about the US, that you need to have some culture of offline privacy. Unfortunately, our bill is about digital. We don't have an offline privacy law properly legislated in one place. So what do you see as the pitfalls? Because the benefits are obvious, right? GDPR's benefits are obvious to humans as individuals. But what do you see as the pitfalls for business in terms of innovation if India was to go all in, so to speak, and try to do a GDPR kind of implementation in India?
Okay. So yeah, thanks. And I think my response is very much in line with this one word which has been common throughout this panel, is the word balance. I think it has to be a balance, and I think there is this perception that, of course, GDPR loggerheads with innovation. To a certain extent, if we look at pure numbers, it's correct. But then there is more nuances to that, and I'll try to touch upon that how it has really stimulated as well as constrained in some ways. And so again, at the core of any legislation, and especially GDPR, is really the individual, the consumer, okay, human right. So that's where, I mean, and it's not just about protection of their rights, but it's also about their choice, the freedom of having choice, multiple supply to get products at a competitive rate. And that comes from innovation, right? The second stakeholder here are the corporations. Of course, they are here to make profit. But what they have realized more and more with legislations like GDPR is that the customer trust is something which cannot be out of the equation anymore. In fact, Accenture has done a research and a study, and they've actually mentioned that, GDPR compliance and the money spent on that kind of compliance is really an appreciating asset in the long run. Of course, a law like GDPR will have some shockwaves or disruption in medium to, I would say, short to medium term. And then the third is really the other lawmakers who are balancing this between the rights of the individual and the corporations. What they need to be sure about is that, while making profits, they just can't be cavalier about the rights of the individual. So they have to do this difficult task of balancing. So coming back to the numbers, now, of course, I mean, in terms of, there was some research that were done, right? So there were 650 apps which were actually studied by, which were on the Google Play Store. I mean, around 86% of people who were surveyed, or the companies, they said that the administrative cost is just too high, or the administrative burden is too high. Around 46% said that, the cost is very high. 36% said they don't understand the legislation and they would rather just pull back. 1 out of around 10, one out of 7 actually said that they're going to remove the app from the store because they cannot keep up with the regulations in terms of, the compliance. And 1 out of 10 decided that after developing an app, they will not probably go ahead with that. So end person who is getting impacted here is really the individual. So again, but at the same time, GDPR is also in some ways a conscious keeper, right? In a lot of ways, it has raised the bar. And like I said, the consumer trust is extremely, extremely important, which GDPR has really raised the bar there. And so one of the research which was done by the National Bureau of Economic Research, they had a very, when they zoomed into this data, pure numbers that is, they actually said that the incremental innovation actually has gone up and radical innovation has gone down, which basically means that people are still innovating, but they're more cautious about it, which is again a good thing, right? They are thinking through about launching something. And of course, they have to be in compliance with the law, which has the cost attached to it. So obviously, they have to have the resources. So that also explains why incremental. And also, a lot of companies were like, let's see when the rubber hits the road and how this is going to evolve, and then we will. So incremental innovation went up, but radical, where maybe things are not thought through, that definitely took a backseat. And out of the 40% people who mentioned that they have been impacted by GDPR, there were a high number of insurance and banking companies. Now, these industry, we expect more in terms of the trust factor, the consumer trust. So that is the good part, right? I mean, they have to be more careful because the kind of data is not TikTok or Candy Crush. I mean, I can't, maybe not TikTok, but so it's, again, these industries owe us more in terms of safeguarding our data. And that's where I think GDPR has done a great job. And I would say, I mean, I'm not in the European context, but if you look at the US for a second, and the example of Mark Zuckerberg in 2018, April, right? Very famous, that video where he's apologizing, that I'm sorry, I mean, we would have done better. I mean, it's fine them to come and say sorry, but that doesn't cut it. And that's not a pretty picture for somebody who holds that kind of control. So laws like GDPR, I think, are keeping that check, necessary evil in some ways. So that's really my take on, I would say,
No,
European.
it's a very interesting take because, you mentioned consumer trust.
Yeah.
And one of the issues that come up, which Nikhil also mentioned, is that we are very mistrusting of, say, an individual person who may have 10, 20 data sets. But culturally, a lot of people, unlike the Europeans, but Americans and Indians for sure, they just click OK to the consents quite easily because of the anonymized nature of the data set. Right? They pretty much show that there's so much data being handed over that it is anonymized, although you'd be surprised how quickly that data can be crawled over by bots and you can be found by them. And in fact, that is another aspect which the government, both in the US, India, as well as in Europe, is working on. In fact, the Europeans, again, are pushing very hard on data gatekeepers being regulated in some way. And India is also mulling that, whether to do it as an amendment to a competition law. But Dr. Garg, pretty much you would be having or owning the largest data set of any entity, maybe, who knows, worldwide at some stage. And you very eloquently pointed out that this is to enable emerging economy to provide public goods. That is the key focus. We also heard that the new privacy law which is coming in does not appear to have that kind of teeth which is needed. Now, I understand that Aadhaar, of course, has its own robust safeguards and mechanisms. So if you could, generally reassure how in Aadhaar you would be actually more protected than you would even be under the digital privacy law, which we are going to soon see.
I can just say that we have our own act, the Aadhaar Act, which was enacted in 2016 and that was amended in 2019. Which has specified very strict safeguards on the data. And the one is in terms of how we store data. In fact, we follow the principle of we encrypt the data, whether it's in rest or in motion. So the moment at the enrollment center when anyone enrolls, it straight away gets encrypted and no one, even that person themselves cannot pull it out, and that's the way our system operates. And the Act very clearly defines something as core biometric data, which is extremely, has a higher level of protection, and the kind of data centers we have, I mentioned about security by design in terms of the different procedures and processes that we follow. So the processes are both technological, which both on the hardware side and the software side that we follow. They are in terms of the kind of monitoring that is done and the audits that are done, both internally as well as of our ecosystem partners. And thirdly, are also in terms of the governance mechanisms which provide oversight whether those technological protocols are being followed, whether those monitoring protocols are being followed. And we also have a lot of inputs coming to us from different agencies who provide us inputs on what kind of cybersecurity threats that might be coming. So I think the kind of firewalls we have, the kind of systems we have, I would be more than confident to say that we are perhaps one of the strongest systems globally. And we keep on innovating and developing it. Even we do hackathons regularly. We are going in for a bug bounty program where ethical hackers, we are inviting them to look at our systems. And we have a sandbox where we experiment with new techniques, with new technologies. In fact, two startups in Bangalore at this moment are working with us on a in a sandbox environment to look at how we can further strengthen our security. So all I can definitely say, the kind of oversight and the kind of importance that we give to these issues is paramount in the Aadhaar, in the UIDAI.
So Dr. Garg is confident. Nikhil, how confident do you feel on Aadhaar? Like, one of the concerns that people have is, in India, we've always had this concept, it's in the Indian Penal Code also, of public servants acting in good faith. So pretty much, if you're acting in good faith in India, you can do anything. So how do you see the checks, especially on the government, in dealing with your data or manipulating it in Aadhaar?
So look, I should be frank that I was actually a big skeptic of Aadhaar, but over the years, the efforts done by UIDAI has actually reassured me. I mean, starting with VID and various acts. In fact, I advised someone to, withdraw a petition relating to Aadhaar recently, saying that, look, many of the things that's been argued in the petition has now been taken care of as privacy by design policy. But that's just with respect to Aadhaar. If you look at other frameworks like ONDC or account aggregator framework, they rely on data blind architectures, right, which promotes privacy. For instance, even if you look at DigiYatra, again, that's a 24-hour sunset clause that's there. But one thing I'd like to see is, we'd like to see some sort of an audit over all these things, right? It should be audited. It should be audited by an independent branch of, the three pillars, ideally the legislative, right? I mean, that will reassure the citizens of this country about the robustness of this framework, right? And now, the unfortunate part is, look, while the government is doing all these things, one thing which is sorely missing from the DPDP bill is the fact that some of the protections that's afforded to core biometrics or, which is very integral to you, is not there in the DPDP bill. We've unfortunately done away with the sensitive personal information classification. And as you know, our data, it's not just collected by the government, which we may trust, we may not trust, but it's been collected by unknown parties across the globe, right? I mean, we can say TikTok is just videos, but fact of the matter is that's feeding into biometrics, right? That's feeding into facial recognition technology, which could be used to surveil us. Or genetic information could flow to an unfriendly country and could be processed in that country, right? As you know, 90% of the CCTV cameras in India are operated by one particular entity. Close to 70% of our Wi-Fi routers and mesh devices in India are from an entity in a very unfriendly jurisdiction to India, right? So given all these facts, it's unfortunate that the DPDP bill doesn't afford the same kind of protection that even Aadhaar Act affords to biometrics. Secondly, it doesn't have a framework for compensation, right? It's a constitutional right to privacy. I can go to a writ court and get a fundamental right enforced against state or private actors, but I cannot claim compensation under the DPDP bill. That is, it's quite unfortunate that we don't have that frame under the DPDP bill.
That is very useful. So, any last remarks anyone wants to make? I think we are at 12:20 now. So if anyone has last remarks or anyone has a question on the floor, please feel free to ask.
But when I look at the subsequent proposed legislation, it actually seems to take away some of those rights. And I wonder if this is a real struggle or it's a struggle only in my mind.
I think it is really the actions that the government takes that, if, for example, they abuse your right to privacy, and that will open up to rate recourse, that will open up to actions under that fundamental right. This legislation primarily is to make a big start to allow data harvesting at least to be subject to some authority. But as we discussed, there will be a lot of subordinated legislation to follow. But Nikhil, if you have any further thoughts on whether Puttaswamy interdicts the law.
So, look, life is a struggle in India. I mean, so I think, so this is also a struggle. So if you look at where we started some years back with respect to the whole privacy debate, which probably started because of Aadhaar, we have come a long way, right? Unfortunately, in the process, by moving away from the 2020 version of the bill, we've probably taken some step backwards from the concept of the human right of privacy, right? That is not necessarily recognized in the bill, like you just said. It should have been better done. I mean, it's, like I said, there is an important duty that the government is trying to serve, which is to grow our digital economy to scales where we can actually leapfrog the lost years that we have had due to, colonization and various other things, right? So that is the intent which is reflected more in the bill rather than protection of human rights, which is what came out strongly in Puttaswamy. Having said that, look, I think we have a robust system in the country with strong legislature, independent judiciary, and the judiciary is never shied away from stepping in where required. For instance, despite the fact that there is actually a carte blanche to the extent that government can collect whatever information that they want, right? I'm sure the courts will step in necessary. For instance, the other thing, I mean, while talking about this, the one thing to keep in mind, despite the fact that our UIDAI framework is really strong and privacy preserving, many of the seeding aspects of UIDAI, for instance, collection of Aadhaar information by the state governments and their database, or even some of the other central government functions maybe, may not be as robust. And we may need to, it's a constant struggle. It's a work in progress. Am I happy as a citizen? I'm not, but I'm sure we'll all reach there. We'll all work towards improving it with, moving to the court, sometime engaging with the government, proactively engaging with the government. And look, in my experience, government has been very receptive when it comes to listening to aspects like data blind architecture and for instance, this DEPA initiative by the government itself is really empowering, right? And that's something that's going to be part of the G20 initiative of the government to put the digital infrastructure of India on the world map, right? So in that sense, government is very receptive when it comes to some of the things. Where not, we are lawyers. We'll go to courts. We'll figure out a way.
Yeah, and one other heartening aspect is that this government considers data not just to be a privacy aspect, but also a national resource. So we do have that very strong policy push that we don't want, to be just a human resource or a human data-rich country. We actually want to be able to use that data. So everything is aligned. In fact, the RBI's charge towards localization was primarily for that purpose, to allow Indian industry to also benefit. So it is positive. Yes, please.
So this is regarding the penalty. I was looking at section 25 and the schedule 1. Now what happens to the smaller companies? You're basically saying anybody who does whatever, it's up to 250 crores. So there's no link to the revenue of the startup. I mean, I'm talking about this from the startup ecosystem perspective, right?
Sahana, what happened to the smaller companies?
I know, what happened?
Yeah.
Great observation. I can tell you that this has been part of the feedback that has gone during the consultation process after the DPDP was released. You're absolutely right that there doesn't seem to be any principles or any factors of consideration when that penalty is to be determined, right? In a lot of other legislations that we've seen in India, there are usually principles or considerations to be followed when the adjudicatory body is trying to impose a penalty. And that seems to be missing or not complete under the DPDP bill. And that has absolutely been feedback that has gone in during the consultation process. Now, assuming that the penalty structure remains the way it is and that there is no threshold or there is no consideration that the DPB will have to give to the size of the company or to its stage of development, whether it is a startup and how big it is, what is the revenue, what is the impact it is creating, etc. I would argue that there is still space for the DPB to take that into consideration, right? There are some principles that the DPB will have to follow in applying that penalty, but I don't think that those are the only principles that it has to follow. And I think given that there are a couple of other mechanisms within the bill where it seems to indicate that the government will want to give some leeway to startups, right? So they're willing to give certain exemptions from certain requirements of the Act to certain types of companies. And And we've heard a lot from the lawmakers about how they're cognizant of the possible impact that this law will have on the bottom line of a startup, right? That is not to say that they don't want the startup economy to be impacted by this law. I think the idea is that because this is a articulation in some way of the protection of that fundamental human right, that anyone who is processing that data, whether you are a big tech giant, I would argue whether you're the government also, or whether you are a startup, needs to be subject to the same requirements. But I think that leeway may still exist for startups. And again, so much will be, proof will be in the pudding.
And if I may add, one leeway that they have put in the bill itself is the use of the word significant in terms of data leaks. So if you're a small company, it is, and this is of course subject to subordinate legislation later on. If you're a small company, you may not be causing a significant data leak because of the sheer amount of data you're handling. But if you're handling a lot of data, then chances are, at least in valuation terms, you'll be a big company. This also happens in startups, that the turnover may not be large, but the valuations are huge.
It's just interesting that they put a 500 crore cap.
Yeah.
Which is, not much for the large companies, but a lot for the
Yeah, but the
startups.
significant part is very important. If you're causing a significant data breach, it's the harm to society. That's what they really focused on, not the person who's causing that harm. Really.
And I think, the fear is valid, but I think the enforcement, I don't think the regulator will have the ability to and the capacity to enforce it and go against smaller companies. Just like in Bangalore, right? I mean, in Bangalore, nobody cares until you're Series B, whether you're complying with local legislations or not. And that's why it is the startup capital of India.
That's all the time we have today. It was a fantastic session. I hope you guys enjoyed it as much as I did. Thank you very much, Dr. Garg, and thank you very much to everyone. Thank you.